Ready, start. The submission on behalf of the petitioner assesses that in the present case the so-called notice for prosecution for assessment year 2013-14 was issued on 12/3/2015 and prior thereto the return of income was filed for assessment year 2013-14 on 29/11/2014 and therefore, the same can to be said to be first offence, cannot be accepted, full stop. In the present case in hand, for assessment year 2011-12, the so-called notice was already issued under section 276cc of the Act on 27/10/2014 for non-filing of return before due date within bracket for assessment year 2011-12 bracket close, and despite the same for the subsequent years, that is for assessment year 2013-14, the assessee did not file return of income before due date of filing of return, full stop. Therefore, again the petitioner assessee committed the offence for assessment year 2013-14, full stop. Thus, it cannot be said that in AY 2013-14 it can be said to be the first offence committed by the assessee, full stop. Under the circumstances, the respondent number 1 has rightly rejected the compounding application submitted by the petitioner, full stop. Rejection of the compounding application submitted by the petitioner is absolutely in consonance with the guidelines, 2014, full stop. Now, so far as submission on behalf of the petitioner that while rejecting the compounding application submitted by the petitioner, respondent number 1 has not properly appreciated and are considered the reason for not filing the return of income by petitioner before due date is concerned, at the outset, it is required to be noted that it has nothing to do with the compounding application, full stop. It is required to be noted that while considering the application for compounding, merits is not required to be considered as is to be considered in trial, full stop. Now, so far as reliance placed upon the decision of the Madras High Court in the case of K. Inba Shagaran within bracket supra bracket close relied upon by the learned advocate for the petitioner assessee is concerned, the said decision shall not be applicable to the facts of the case on hand, more particularly, while considering the compounding application, full stop. In the case before the Madras High Court, 3 different complaints for the offence under section 276cc of the Act for Assessment year 1991-92, 1992-93 and 1993-94, though were filed and numbered separately, were clubbed together in one case, and the learned magistrate passed the orders holding the accused guilty under section 276cc on 3 counts, full stop. The question arose whether the offence for which accused was charged were distinct or separate and not in any way interrelated, and when each offence had no connection with other, joinder of charges would become bad in law or not, and two, that it has been observed and held by the Madras High Court that framing of charge was defective and violative of sections 218 and 219 of the Code of Criminal Procedure, and as judgment was rendered only in one case and there was no finding of guilt recorded as regards 2 other cases, the Madras High Court has observed that error committed by the trial court was of such grave nature that it had caused prejudice to accused, and therefore, in that view of the matter, conviction and sentence passed by the lower court has to be set aside, full stop. Therefore, the said decision shall not be applicable to the facts of the case on hand, full stop. Now, so far as reliance placed upon the decision of the Delhi High Court in the case of Sport Infratech within bracket P bracket close limited within bracket supra bracket close relied upon by the learned counsel for the petitioner is concerned, the said decision also shall not be applicable to the facts of the case on hand, full stop.